Welcome back to QHSE Talks, where we move beyond surface-level safety discussions and focus on what truly defines professional competence in today's high-risk, highly regulated environments. In this episode, we continue our CSP certification series, following David Yates' Safety Professionals Reference and Study Guide, and our focus is Chapter 2, the legal aspects of the safety profession. This chapter is a turning point in the book because it makes one thing very clear. Safety is no longer evaluated only by incident rates or technical controls. It is evaluated in courtrooms, regulatory hearings, and compensation claims. Today's safety professional is expected to understand workers' compensation systems, OSHA authority, administrative law, civil liability, and how judicial decisions shape enforcement and accountability. This chapter explains why safety decisions must withstand not only operational scrutiny, but also legal, financial, and ethical examination. Yates walks us through the constitutional foundation of U.S. law, the structure of the court system, and the three categories of law that directly affect safety practice: statutory law, administrative law, and case law. Then he connects those foundations to real exposure through tort law, negligence, strict liability, product liability, and vicarious liability. The message is direct. If you are responsible for protecting workers, you are also responsible for understanding the legal framework that governs every safety decision you make.
And that level of sophistication, it's just not optional anymore. Modern safety roles demand a significantly increased, an in-depth knowledge compared to the early days of the profession.
It's a different world.
It is. We're operating in this multidisciplinary environment where the legal and financial stakes of any incident are just astronomical. You have to be able to navigate the entire legal ecosystem.
Okay, let's unpack this. So let's start with that central premise that Yates lays out. The job description for a safety and health professional today, it's dramatically different and, frankly, far more legally exposed than it was even, 20 years ago?
Oh, easily.
So what's the historical change that's driving this need for deeper legal knowledge?
It's the sheer complexity of it all. And, the massive proliferation of regulatory and civil litigation risks. The sources make it crystal clear that the professional's expertise today has to cover not just the technical side of things.
The chemistry, the engineering, the IH work.
Exactly. All of that. But it also has to cover the comprehensive legal aspects, where safety used to be, pretty much purely about compliance with prescriptive standards.
The guardrail needs to be 42 inches high.
Right. That's it. Now it's about managing global risk and financial exposure.
So it's not enough to know how to design a compliant scaffold anymore. You have to understand the legal outcome when that scaffold fails, and more specifically, who in the organizational chart is going to be held legally liable.
Precisely. The shift is from prevention, primarily, to prevention and defense. And we identify 4 key legal areas in the source material that every safety pro really has to master. And they go way beyond just, checking a box on an OSHA form.
Okay, what are they?
They are workers' compensation, product liability, strict liability, and of course the big one, the ubiquitous OSHA regulations and standards.
Okay, workers' comp is sort of the obvious one. It's the financial backbone of how we manage injuries. But I want to jump into product liability first, because that can be a tricky one.
It can.
Why is product liability so critical for an in-house safety professional, especially if your company doesn't even manufacture products?
It's a direct function of your advisory role. Think about it. If you, as the expert, advise management to purchase and implement a specific piece of equipment, a chemical, a type of PPE.
Okay, so like picking a specific kind of intrinsically safe relay for a hazardous location or a certain fire-resistant garment.
Perfect examples. And that product fails to protect an employee. Now the employer can become a defendant in a third-party suit.
So let me get this straight. The safety manager signs off on using a specific brand of safety harness. That harness has a manufacturing defect. It leads to a fall. The employee, obviously, sues manufacturer. The employer gets dragged into that lawsuit as well.
Almost always. Precisely. The organization gets exposed to product liability claims, and often the argument is failure to warn or failure to adequately train on the product's limitations. Your professional hazard determination, that documented rationale for why you chose that specific piece of PPE or equipment, that becomes critical legal evidence. If you failed to choose a product that was appropriate for the foreseeable use and hazard, your due diligence gets called into question. Your expertise has to inform those procurement decisions to mitigate that risk exposure right up front.
Wow. That really makes the safety professional a key gatekeeper in the supply chain, not just on the operations side.
It does.
Okay, let's pivot to the regulatory component, OSHA. The Occupational Safety and Health Act is the statute, right? That's the foundational law. And the standards, like, say, 29 CFR 1910 Subpart D for working surfaces, those are the administrative law. So how does the professional bridge the technical details with that legal requirement?
The professional really acts as the indispensable interpreter. Take the hazard communication standard, for instance.
Oh, classic.
It is. And it's an administrative law masterpiece of detail. It doesn't just say, train your employees. It demands that the chemical manufacturer assess hazards using these very specific criteria based on concentration thresholds for health hazards, like determining if a mixture is classified as a carcinogen if certain components exceed, say, 0.1%.
And what if those chemicals are volatile or explosive?
Well, then you're diving into the physical hazard classifications, which are dictated by standards like flashpoint or the lower and upper explosive limits, the LEL and UL. So the safety professional has to manage this sheer volume of 16-section safety data sheets. They have to make sure secondary containers are labeled correctly with the pictograms and signal words. And then they have to ensure that the employee training covers all the physical and health hazards that are listed back in Section 2 of the SDS.
And if you miss one of those granular details...
A citation. A citation for violating the administrative law. It's that simple.
That level of detail? I mean, that's exactly why the General Duty Clause exists, isn't it? Section 5A1 of the OSH Act, the mandate for employers to provide a workplace free from recognized hazards, that's the ultimate legal catch-all.
It is absolutely the OSH Act's most powerful provision, legally speaking. If an employer is exposed to a hazard that is not covered by a specific standard.
Like we were saying before, maybe an emerging ergonomic risk with a new robotic assembly line.
Right, or even a complex psychological hazard like workplace violence. The professional have to be able to argue effectively to management that this still constitutes a recognized hazard under the General Duty Clause, and therefore it necessitates controls.
And that requires a legal understanding, not just a technical measurement.
Absolutely. You have to prove, often based on industry recognition or just common sense, that the hazard is real and it's likely to cause harm.
So if we go back to that analogy of the safety professional as an architect, they have to understand the foundation, the constitutional and statutory law, before they can even start designing the building, which is the safety program.
That's it.
They have to be fluent in engineering, toxicology, and law. It makes them this crucial translator for the entire company. And without that legal grounding, the whole safety structure is just vulnerable to collapse in court.
A very vulnerable structure indeed. If your program fails the legal test, if you can't prove due diligence based on reasonable care and a comprehensive hazard evaluation, then your whole organization is exposed, both regulatory and civilly.
All right, so we're moving now from, the shop floor and the day-to-day regulatory stuff to the very roots of American jurisprudence. So why on earth must a safety professional who's concerned with machine guarding and chemical exposure limits spend their time trying to understand the U.S. Constitution? Isn't that overkill?
It is absolutely not overkill. And here's why. Every single federal regulatory law, and that includes the Occupational Safety and Health Act, derives its authority directly from the U.S. Constitution. It is the ultimate source of all regulatory power in the country.
So if OSHA oversteps its bounds...
It's always the Constitution that determines whether that regulation or that enforcement action is legitimate. Yates's guide provides this framework so you can understand the limits of government power when an inspector walks through your door.
Let's start with the structure that creates the law then. Article 1, which defines the legislative branch, Congress.
Right. Article 8 lays out that structure. And, while a lot of the sections deal with the mechanics of Congress, like Section 4 details that the time, manner, and place of elections are vested in state legislatures, or Section 5 on how each chamber judges its own members, the core takeaway for us is this. The body that wrote the OSH Act operates within tightly defined parameters. The authority they have is not absolute.
And that is the crucial insight. It's not really about who gets compensated under Section 6, which authorizes pay for members. It's about recognizing that the legislative source of the OSH Act is fundamentally limited by the very same Constitution that grants it power in the first place.
Exactly. And the most immediate, the most critical limitations on that power, especially when it comes to enforcement, they come from the amendments, specifically the Bill of Rights. These fundamentally structure the relationship between the government, in our case, OSHA, and the regulated entity, the employer.
Okay. Here's where it gets really interesting.
It does.
Let's focus intensely on the amendments that would directly impact an OSHA inspection or an accident investigation. I mean, we can mention an amendment, freedom of speech, assembly, petition that could relate to an employee's right to discuss safety issues without reprisal.
Sure.
And, Amendment 2, the right to bear arms, and Amendment 3, prohibiting quartering soldiers. They establish foundational rights about security and property, but we need to really drill down into the two amendments that are most actionable for a safety pro who's dealing with enforcement.
Without a doubt, we have to focus on the Fourth and Fifth Amendments.
Yeah.
They're your shield when the regulator shows up at the door.
Okay, let's start with Amendment 4, the protection against unreasonable searches and seizures. In the context of an OSHA inspection, what does this actually mean in practice?
Okay, so Amendment 4 dictates that the government cannot conduct an unreasonable search without a warrant, and that warrant must be supported by probable cause. For a safety professional, this means that if an OSHA inspector arrives without a warrant, which they often do, the company has the constitutional right to refuse entry.
Okay, but that refusal comes with risk, right? The inspector will usually just go get a warrant.
They will. They'll go get what's called an administrative search warrant from a federal magistrate.
So wait a minute. If the company refuses entry, the inspector just comes back a few hours later with a warrant. Does that mean the Fourth Amendment is basically just symbolic in this case?
Not at all. It's a protection of due process. It is so important. The inspector cannot simply force their way in bent on a hunch or suspicion.
Okay.
To get that administrative warrant, they still have to show probable cause. And in this context, that usually means demonstrating there's an existing employee complaint, or there's a recognized hazard in that industry, or simply that the business is on a high hazard list for programmed inspections.
And the warrant itself has limits.
Huge limits. Once they have a warrant, the scope of that inspection is usually limited to what is stated in the warrant. So if the warrant says they are there to inspect the welding shop for confined space hazards, they can't necessarily just pivot and start inspecting the accounting office for ergonomic risks without broadening that warrant.
So the Fourth Amendment gives you the right to control the scope and, crucially, the timing of that inspection.
Yes, that distinction is critical. It gives the employer a brief but really important window to engage legal counsel and prepare.
Okay, now let's talk about Amendment V, the right to due process and the protection against self-incrimination. How does this play out during, say, an accident investigation?
This is where that protection against self-incrimination becomes absolutely vital, especially for management personnel. During an investigation, OSHA or other agencies will want to interview managers, supervisors, maybe even the CEO.
And they have to talk.
No. The Fifth Amendment ensures that no person shall be compelled in any criminal case to be a witness against himself.
And what about documents? Does this apply to my paperwork? If OSHA demands all my maintenance records for the last 5 years, am I protected?
So generally, the Fifth Amendment protects testimonial evidence, what you say. Now, a corporation doesn't have the same protections against self-incrimination as an individual person does.
Okay.
But the documents themselves are still protected under due process principles outlined in the Fifth Amendment and elsewhere. They can't just be seized arbitrarily. You have the right to challenge unreasonable demands or provide documents only under specific agreed-upon terms, often through your legal counsel. The Fifth Amendment ensures fair proceedings and notice before life, liberty, or property can be taken.
So knowing your rights under the Fourth and Fifth Amendments is basically step one in legally managing any enforcement action.
It's foundational.
Let's briefly touch on a later but financially massive amendment, Amendment Lex Seist.
Ah, yes. Amendment 16th, ratified in 1913. This is the engine that funds the entire regulatory state. It's the one that grants Congress the power to lay and collect taxes on incomes from any source without apportionment among the states.
So without income tax.
Without the ability to collect taxes on income, the federal government would lack the massive financial capability it needs to fund these complex nationwide agencies like OSHA, the EPA, OSHA, all of them.
In other words, the safety professional needs to know about the 16th Amendment because it explains why the regulatory body has the budget and the manpower to conduct inspections and issue citations in the first place.
It's the enabling financial power. Understanding the Constitution isn't just some academic exercise. It's about understanding the ultimate source, and just as important, the limits of the authority that governs your workplace every single day.
We've established the constitutional framework, the source of power, and the limits on that power. So now let's transition to the actual working components, the court system, and the different types of law that govern our day-to-day safety decisions. When we talk about enforcement and liability, we always hear about the federal court system versus the state court system. Why is it so vital for safety professionals to understand this parallel structure?
Because your legal problem is going to be heard in one or the other, and that dictates everything: the rules, the precedents, the final outcome. The U.S. operates on these two parallel tracks. Federal courts generally hear cases involving federal laws.
Like the OSHA Act.
Exactly. The OSHA Act, the Clean Air Act, or cases involving constitutional rights. So if you appeal an OSHA citation that's gone through the Occupational Safety and Health Review Commission, OSHRC, it often ends up in a federal circuit court.
In the state court system, what's its role?
That's where the vast majority of day-to-day legal issues get handled. Things like contract disputes, property disputes, and really importantly for us, most civil tort claims and all workers' compensation cases.
So even if an injury happens at a federally regulated facility,
Even then, a lawsuit filed by that employee against, say, a third-party vendor or a negligence claim against the company itself outside of that exclusive workers' comp remedy that will typically proceed through the state courts.
let's look at the very top of the pyramid, the Supreme Court. The source material really emphasizes its specific and often misunderstood jurisdiction. We all know they don't hear every case that gets appealed.
Far from it. The Supreme Court is highly selective. The reference material notes that the court has original but not exclusive jurisdiction over a few very specific high-level cases, like those involving foreign ambassadors or diplomats or disputes between states.
But the vast majority of cases get to them via a writ of certiorari. That is a huge mouthful. Can you give me the one-sentence, non-lawyer definition of what that means for our listeners?
It means they only take cases when they choose to. A writ of certiorari is essentially just a request for the Supreme Court to review a lower court's decision. They usually grant it when there's a massive conflict in the law between the different federal circuit courts or when a constitutional question is so profound that it needs a national resolution.
So they're not an appeals court for every little disagreement.
Not at all. They are the guardians of national legal consistency.
So if a safety professional is dealing with a major multi-million-dollar OSHA fine, they really shouldn't count on the Supreme Court swooping in to fix the problem, unless that citation truly changes the face of regulatory law for the whole country. It just reinforces the need to win your case at the administrative and circuit court levels.
Absolutely. The Supreme Court is interested in what the law means for the nation, not who won or lost a particular case in Alabama.
Okay, so now let's look at the law itself. The three pillars that govern the safety environment. We have statutory law, administrative law, and case law. Can you explain how these build on each other using a practical example?
Of course. Let's use the Control of Hazardous Energy Lockout-Tagout as our model.
Perfect.
Okay, so first you have statutory law. This is the foundational law written by the legislature. In our case, the OSH Act of 1970 is the statute. It delegates authority to the executive branch to make the rules necessary to ensure worker safety. It sets the broad goal.
Okay, so that's the big picture. And second is administrative law. This is where the rubber really hits the road.
This is it. Administrative laws are the rules and regulations that the agencies create to fulfill the statute. For lockout-tagout, this is 29 CFR 1910.147. This administrative rule details very specific requirements.
Right. It defines what energized means. It specifies training frequency.
It mandates the development of machine-specific written procedures, and it dictates the requirements for verification of a zero-energy state before any maintenance begins. This level of granular detail could never be legislated by Congress. It has to be written by the expert agencies.
And finally, case law enters the picture. This is where judges interpret the administrative law and, in doing so, create precedent. How does that affect something like lockout-tagout?
Case law provides the crucial context. So, imagine a company has a detailed OLOTA procedure, but an employee gets injured because the supervisor, instead of using the written procedure, just verified the machine was off by watching a light go out.
Okay.
The company might argue they complied with the spirit of the law, but a judge reviews the case and might rule that simply watching a light does not fulfill the requirement for a positive test of the zero-energy state.
Yeah.
Or that the supervisor's actions violated the duty to train. That judicial interpretation now becomes case law. It's a precedent. And it dictates how all other companies must interpret that requirement for verification of zero energy state in the future.
So the law is this living three-part system. The statute grants the power, the administrative rules give us the technical detail, and then the case law sharpens the application of those rules in the real world. A professional who only reads the CFR is really only reading 1/3 of the applicable law.
That is the essential takeaway. If you ignore the precedents being set by OSHRC and the federal courts, you are operating with an incomplete and, frankly, dangerous understanding of your legal obligations.
All right, let's shift our focus now entirely to civil litigation, the area of torts and liability, which so often dictates a company's financial survival. First things first, what exactly is a tort?
A tort is simply a civil wrong. It's a breach of a legal duty that's owed by one person to another, which leads to some kind of injury or damage, and the injured party can then seek money damages. It's completely distinct from criminal law or regulatory enforcement.
And most personal injury claims, most civil lawsuits related to safety failures, they fall under tort law.
That's right. And the most common type is the negligent tort. This is where we see that concept of a lack of reasonable care really being defined.
Okay.
So in a negligent tort lawsuit, the plaintiff, that's the injured party, is suing an individual or an organization for causing harm because they failed to exercise reasonable care. And to win, the plaintiff has to prove 4 classic elements.
What are
1, the defendant had a duty. For example, an employer's duty to maintain safe equipment. 2, the defendant breached that duty. They failed to perform reasonable maintenance. 3, that breach was the causation of the injury. And 4, the plaintiff suffered damages, like medical bills or lost wages.
Can you give us some tangible examples of safety failures that trigger these kinds of negligent tort claims from the guide?
Oh, the examples are ubiquitous. They're in every workplace. Slips, trips, and falls from poorly maintained facilities. A facility manager ignoring a known broken step or a continuously wet floor.
Right.
Automobile accidents caused by reckless driving by an employee in a company vehicle where the company failed to enforce safe driving policies. Injuries from improper equipment operation where the employer failed to train or maintain the machine. A supervisor letting someone use a lifting device they know is faulty. The core question is always, did the employer act as a reasonably prudent, careful person would have?
That seems like a manageable standard. I mean, if you follow best practices in administrative law, you're building a pretty strong defense against a negligence claim.
You are.
But then we hit this other legal concept that strikes fear into the heart of risk managers: strict liability. What makes this standard so fundamentally different from negligence?
This right here is the aha moment in legal risk management. Strict liability means the defendant is liable for damages even if they were not negligent.
Wow.
The plaintiff does not have to prove a breach of duty. They simply have to prove that the defendant's activity caused the harm.
Wait, hold on. If compliance isn't a defense, isn't the law basically telling us that we can never fully mitigate that risk? I mean, that feels like an impossible standard for management to meet.
It's not impossible, but it demands absolute control and a lot of financial preparedness. The principle is rooted in this idea that some acts or conditions are just so inherently hazardous by their nature that society has deemed it appropriate for the party engaging in that activity to bear the full cost of any harm, regardless of how careful they were being.
What are the specific examples of these kinds of inherently dangerous acts?
The classic legal examples include things like keeping dangerous animals, engaging in ultra-hazardous work like deep excavation, or, and this is critical for industry, blasting operations.
Right.
So if a construction company is blasting rock to prepare a site, and they follow every single federal and state protocol perfectly, they use the right charge, they notify the neighbors, they time it correctly, but the vibrations cause some unforeseen structural damage to a neighboring building.
They're still liable.
They're still liable under strict liability. They pay the damages because the activity itself is inherently dangerous.
And in modern industrial safety, I imagine this extends heavily into environmental liability, right?
Mm-hmm.
Managing hazardous waste, dealing with catastrophic chemical release potential, handling highly volatile materials.
Exactly. Even if you follow the Resource Conservation and Recovery Act RCRA guidelines to the absolute letter, the inherent hazard of that waste stream remains. You are exposed to strict liability should a release occur.
It's why environmental and safety pros are now often tasked with looking at the total legal exposure, not just checking a box for regulatory compliance.
It is. If a catastrophic event happens with these high-risk materials, management can't just hide behind, but we had all the permits. The focus shifts from the conduct to the consequence.
This leads us directly to the practical management of that financial liability through workers' compensation and this crucial distinction between liability and reportability.
This concept is arguably one of the most critical legal insights for any practicing safety professional, and it is so often misunderstood by new managers. The source material really emphasizes this. Reportability to OSHA should not be confused with compensability under workers' comp laws. They are two entirely different legal systems with two totally different goals.
Okay, walk us through a practical example of that.
Let's take a simple wrist strain. An employee lifts a box, feels a twinge, goes to the doctor. The doctor prescribes rest, some anti-inflammatory medication, and a physical therapy program. So from the OSHA perspective, reportability. If the injury required only a doctor's visit and the employee came right back to work without any restriction or lost time, it may only be a recordable incident on the OSHA 300 log. It's likely not reportable directly to OSHA, which requires hospitalization, amputation, things like that.
And on the other side, workers' compensation, the compensability side.
The injury is fully compensable. Workers' comp is a no-fault state-level system. As long as the injury arose out of and in the course of employment, the employee is entitled to that medical care and any lost wages, if applicable. The standard for compensability is incredibly broad. A simple sprain that just requires prescription-strength painkillers and 3 sessions of PT is entirely compensable under state law, even though it's not a severe, reportable OSHA event.
So a safety professional has to manage 2 totally separate data streams for the exact same incident, and each one is governed by different laws. One for regulatory compliance, the other for financial liability.
And that financial liability is massive. It's primarily driven by the experience modification rate, or EMR. This is where the cost of those claims really hits the company's bottom line.
The EMR.
The EMR is a multiplier that's applied to a company's workers' compensation premium. It's calculated by comparing the company's actual incurred losses, the total dollars paid out in claims over the last 3 to 5 years, against the expected losses for companies of a similar size in the same industry.
I need a little more detail there. How exactly does the safety professional influence this EMR number?
Okay, so if your EMR is 1.0, you're paying the industry average rate for your insurance. If your EMR rises to, say, 1.5, you are paying 50% more for insurance than your direct competitors are.
That's a huge competitive disadvantage.
It is. And the safety professional directly impacts this by managing claims aggressively and efficiently. You have to focus on injury prevention, of course, but also on claim management.
So implementing swift return-to-work programs, providing light duty.
Investigating incidents promptly, and ensuring claims aren't being overpaid or just left open indefinitely. Every single dollar you save in claims is a dollar that prevents that EMR from spiking, which in turn saves hundreds of thousands, maybe even millions, in premiums down the line.
This really elevates the safety professional into a critical financial strategist. You're not just preventing falls anymore, you're protecting the corporate balance sheet by understanding the financial implications of state-level tort and workers' comp law, completely separate from federal OSHA enforcement.
The difference is profound. OSHA focuses on violations of standards. Workers' compensation focuses on the cost of injury. You absolutely have to master both systems to succeed.
Wow. We've traveled from the 1791 ratification of the Bill of Rights all the way to modern EMR calculations. I mean, we've covered the comprehensive legal landscape of the safety profession. Let's just briefly recap the 3 major learning blocks we covered, because they are essential for any professional managing risk today.
Sounds good. First, we established the constitutional bedrock. The understanding that all regulatory authority flows from the Constitution, but it's also strictly constrained by the amendments, especially the 4th for search and seizure during inspections, and the 5th for due process and self-incrimination during investigations.
Right. And second, we clarified the 3 pillars of law. Statutes, like the OSHA Act itself, administrative rules, the detailed standards like 29 CFR 1910.147, and case law, which are the judicial interpretations that set precedent and define how those rules actually have to be applied.
And third, that crucial distinction in liability. Recognizing that while negligent torts require proving a lack of reasonable care, strict liability applies to those inherently hazardous acts, like certain chemical processes or blasting, which means liability exists regardless of your due diligence. And of course, we emphasize that mastering the financial liability of the EMR through superior workers' comp management is a core legal and financial duty.
And the relevance to you, the longer, is that mastering this framework lets you step into that advisory role with real confidence. You can effectively advise management on procurement risk product liability. You can predict legal exposure based on your operations, strict liability, and you can understand the financial limits of your programs through the EMR. You're not just managing risk, you're managing legal authority and financial solvency.
And, we spent a lot of time today on that distinction between an injury being reportable to OSHA and compensable under workers' comp. Those differing legal goals, one focused on regulatory compliance, the other on employee financial remediation, they can sometimes feel contradictory.
They really can. And since the legal system relies so heavily on both statutes and the evolving interpretations of precedent case law and that ultimate catch-all, the general duty clause, it raises a final and I think powerful question about legal foresight.
It does. And the final provocative thought for you to carry forward is this. Since the legal duty is defined by what the law allows and what precedent demands, how must a safety professional anticipate the spirit of the law? The core principle of absolute protection, even when a hazard or an injury technically falls outside the current reporting thresholds. What must you do today to preempt the wave of civil liability that case law is going to define tomorrow, and thereby truly fulfill the core legal duty of providing a safe workplace? It demands not just compliance, but genuine legal foresight.
That is a powerful challenge for every professional out there. You are not just complying with the past, you are legally obligated to anticipate the future. Thank you so much for joining us for this deep dive into the indispensable legal pillars of the safety profession. We hope you feel far more informed and equipped to navigate the complexity of risk management.